I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Tonight for 253, we are celebrating Ladies' Night. That's right, we're going to be in 4 different judges' courtrooms, all female judges, of course. Before I give you their names, don't forget to like, comment, share, and subscribe. Commentary will be left in if there were any from before, and chapters will be added for your convenience. Now, let's see who our ladies of the night are for this compilation. First, it is Judge Arienne Slay out of the state of Michigan. Second, it is Judge Jaime Horowitz, also out of the state of Michigan. Third, it is Judge Mara Rozanno out of the state of Washington. And last but not least, it is Judge Raquel West out of the state of Texas. Hey, once again, we're celebrating Ladies' Night. Ladies, shout out to you. Enjoy, fellas, as well. And now, 253.
Numbers 31 and 32, People versus Taft Lewis, 16432 FH.
Well, this was adjourned from last week. So here we are.
Here we are. You have the opportunity to speak to Mr. Lewis.
Not really directly to Mr. Lewis. We did mention to Mr. Judge Conlon that I was thinking, based on the fact that he's been struggling financially, if the court would be willing to waive the waivable fees, that would leave him a $73 mandatory balance. We never really got that far. So,
Okay. All right. I see there's a range on bench warrant. He'll owe 73.
yes, that's correct.
What's the amount of the waivable?
He owes $2,045.80. Of that total, $73 is mandatory,
Okay.
and he's paid $125 so far.
Mr. Attorney General, what do you have to say?
Well, I guess I'm not entirely clear on the basis of the violation. I don't have. I'm not sure I've received documents regarding that. With respect to the underlying child support case, Mr. Lewis currently owes $21,415.70, and he has a current obligation of $66 a month. That's 66. And his last payment was in August of 2022. Further, I also am not sure if Mr. Lewis has any representation in this matter or not.
No, I'll be representing myself.
Oh, okay.
I have PD written down here, but
I did try and see him this morning, Your Honor, but he said he's representing himself.
Yes, ma'am.
oh, okay. So I'm sorry. I thought Mr. Gaddy was here on this. Sorry.
There's 2 issues,
Okay.
the collections issue and then the probation violation.
Okay. So as to the collection issue, I can waive the waivable amounts. And Mr. Petherbridge, if you submit an order for that, leave
Will do, Your Honor.
balance at 73, you said?
Yes, that's correct.
Okay. And Mr. Lewis.
Can I speak now, Your Honor?
Yep, just a minute.
No problem.
Okay. Mr. Lewis, pursuant to Court Rule 6005, you have the right to the assistance of an attorney. So I can read you this section here if you're interested in
No, ma'am.
representing yourself.
Yes, I am, ma'am.
You are interested in representing yourself.
Yes, I've been
Okay, hold
representing
on.
myself since 2010, ma'am.
Okay, well, so then you've probably heard this a time or two, but we're supposed to read it to you every single time you come to court.
No problem.
Okay, so hold on just one second. Says here under subsection D, the court may, and this is in the initial waiver, so I'm assuming some other judge did this for you, but if not, here it goes. You are being advised that of the charge that you have in front of you, the violation of probation for which you have a VOP that is pending, alleges that you violated condition number 3 about making a truthful report to your probation officer monthly, as that they required, and that a failed You failed to report on 1/26/23, and that you, on 1/27/23, a call was placed to you and contact was made. You said you were going to turn yourself in on the warrant. The potential penalty in this case is up to 5 years and or $5,000. And I will read this verbatim. Advising the defendant of the charge, the maximum possible prison sentence for the offense, any mandatory minimum required by law, and the risk involving self-representation. In addition to that, I will offer you the opportunity to consult with a lawyer that you can retain of your choosing. Currently you're in custody, so I'd also appoint the public defender's office if you wanted assistance. And that's my understanding that you are not interested.
No assistance needed, Your Honor.
Okay. This is your choice. All right, so how are we proceeding with the violation of probation?
Your Honor, I don't respect the reason I'm here today, but I will not disrespect your court because of others' egregious actions towards me. This is our first time meeting, and I plan on it being our last. Before Mr. Breckenbridge left, I would have liked to address the whole panel. So that I had just a few questions for him to set precedent so that everyone's stance could be evident and clear and no misinterpretations. But I see Mr. Breckenbridge tucked tail and ran.
Well, we're making a recording and he's still here. He just was out of the camera view.
Great. Mr. Breckenbridge, can you please state your full name and title for the record?
Scott.
Mr. Lewis, this is not your hearing.
I can't address the panel.
There's no panel.
You have the probation officer, you have the court fines and fee officer, and you have the assistant general.
And everyone put their appearances on the record. So we're going to move it along.
No problem. I can get right to it. That is fine.
All right.
The law is my protection, and I shall find remedy in it. Before we begin this process, I would like to address the court. In addressing the court, I would like to fully read and completely express all information today without interruption. I have two questions for the court. First question is, are all laws commercial? Second question.
Mr. Lewis.
Yes, ma'am.
We have a violation of probation in front of you. I understand that you have been arraigned on the violation of probation. And because you are decided that you want to act as your own counsel, I will hold you to the same standards as I would any other defense counsel in this same procedure and within this same case. So, as to the violation of probation, you can accept responsibility by pleading guilty to the violation or no contest. You can set this matter for a hearing in which we go forward, but this is not your hearing to run. Do you understand?
Yes, ma'am. I just wanted to address the court and put on record some very variable value information. And by
asking me questions is not putting information that you have on the record.
Yes, ma'am. I won't ask any more questions. Can I finish my statement? I have no more questions.
My question for you is, how are we proceeding with the hearing today? Are we proceeding with an acceptance, or are we proceeding that we need to set this matter for hearing?
Ma'am, this is not even a hearing that we should be having. If I could finish my statement, you could see that unless the AG has certain information, this is totally in violation and I'm not able to express myself. Like I said, I have no more questions. I just would like to read the information I have, and then they can go which direction they want to after the information has been expressed, ma'am.
Okay, tell me if you feel like the petition for your violation of probation is wanton in some regard.
It is not wanted at all, Your Honor. I shouldn't be.
It's not wanton?
I shouldn't be.
So you believe that it's accurate?
No, I believe it's inaccurate. I believe me being on probation is inaccurate.
Okay. Quickly, Mr. Taft Lewis.
I can finish. Thank you. I am the de jure. I am not an imbecile in law. I do not surrender my inalienable rights for any civil liberties. I am a five-fifths realized being and not a three-fifths dressed got compromised imbecile in law. I'm here today for the non-payment of what is commonly known as child support. For the record, there's no such thing as child support. The reason I'm here today is because you're trying to enforce a contract/agreement by forcing me or compelling me to be a surety for
Mr. Lewis, are you telling me that you're a sovereign citizen and you do not believe that the
Ma'am,
orders of the court apply to you?
No, ma'am, I'm not sovereign at all. I'm just speaking, I'm just expressing why.
That's what you just said.
I said I'm a 5/5 realized being, ma'am.
Okay.
That's
So
not.
these are, I need you, if you can't answer my question, we're gonna adjourn this until you can get a hearing, and I'm gonna appoint standby counsel of the public defender.
I don't want
Thank you.
counsel, ma'am. I just want to finish.
I understand that. So what I want you to do, and you don't have to have Mr. Gaddy right next to you during your event, but your hearing for next week. But what I want you to do is talk to him about your available option, because what's very clear to me is that you're not listening to the questions that are being posed to the court. Right? I say, are we having a hearing or are you accepting responsibility? I need an answer to that before we can go forward. You making a statement isn't evidence. That's not evidence, Mr. Lewis. And because you want to represent yourself, you're going to be held to the same standard as if you were a defense attorney appearing in front of this court. You can change your mind about that and have Mr. Gaddy represent you.
No, I don't want any.
But in the meantime, I'd like for you to talk to him in the next week so that you guys can discuss what the proper way is to go about dealing with the court. Because as of right now, you're not following the proper criminal procedure. You don't get to just make statements. There's an order to things. So you can find that out for Mr. Gaddy. This case is adjourned until next week. We'll see you back on the 6th. Or exactly, Ms. Armstrong, does that give you enough time, or do you need to put it up 2 weeks?
Be released.
Oh, sorry, Mr. Attorney General, does that give you enough time to do a writ, or do you need more time than that?
Judge, our office will request 2 weeks, just to ensure we have time.
We'll put it out 2 weeks.
Am I being remanded to jail, ma'am, or am I free to be released and come back in? Because I came in on my own accords, ma'am. I have no problem with coming back. Whatever day.
I'd like to make a bond motion, I'll hear that.
Yes, I would.
First, I'll put the recommendation from probation on the record.
Thank you.
The recommendation is for Mr. Lewis to serve 4 days in jail with 4 days credit. And to report to Agent Priest, to report to probation on March 2nd in the office. Your Honor, I'd also like to make note that I have a note here that indicates. Your Honor, may we approach?
Yeah. I'm sorry, ladies and gentlemen, for those of you, we need to have a private conversation because we have Mr. Attorney General is not here in person. We have to clear the courtroom. Separate that prosecutors. Okay, Mr. Task Lewis, got additional information. You know, if you wanted to see me, there's a different way to do that. If you have a motion, or part of that is by working with an attorney who knows how to navigate the procedures of the court. Again, your choice not to use an attorney. I still have the standby counsel for the public defender should you choose to avail yourself of their decades of legal knowledge that might help you navigate this process.
Ma'am, I thought this was the hearing. I didn't know it.
Pardon?
I thought this was the hearing because last week I could not speak also because he said it was your case and I would be able to have my turn to speak when I was in front of you. Now I'm in front of you and you're telling me this isn't the hearing also. So I didn't know how you guys were going to proceed. I just want to be heard on what information I have. Like I said before, I asked for this warrant so that I could get in front of you, so that I could say this information to see which way.
And Mr. Taft Lewis, that's exactly what I'm saying, is that you had used the assistance of the public defender's office or your attorney who assisted you at the time of your case, you wouldn't have had to violate your probation to get in front of this court. I don't believe that you are a flight risk. I think you just made poor decisions. So I am going to release you, but you're to respond here in person, which is March 6th.
No problem.
On Monday at 1:30, and that is the date and time set for your hearing.
Yes, ma'am.
At that time, I would expect you to follow the proper procedure that any other criminal defense attorney would be held to the same standard. You still have the public defender at your disposal if you choose to consult with them.
No problem.
Could you also order him to report in person to probation office on?
You'll have to report to probation tomorrow. I'm sorry, March 2nd.
Yes.
You'll report to probation on March 2nd to meet with your agent.
Which agent is that? Is that Agent Moses, Agent Miller, or Agent Priest?
Agent Priest.
No problem.
Your Honor, if I could ask Mr. Lewis to contact my office and give us the, address and phone number.
Did you hear that, Mr. Lewis? The public
Yes, I did.
defender is availing themselves to you.
I have no comment on that, but yes, I did hear him, ma'am.
I'm releasing you on PR.
Much appreciated, ma'am.
Okay, we
Is
will
that on
see you
all-
back
is
here.
that on all warrants? I had 3 warrants, one from the court fees and fines, I had one from FOC, and one from the violation of probation. Is that all warrants? I'll be released on PR?
Yes, and yes.
Much appreciated, ma'am. I will see you March 6th at 9
See you
a.m.
then. It's 1:30 p.m.
On
1:30.
March 6th.
Be there at
March
1:30.
6th.
Yes, March 6th. I'll
Okay.
be there.
All right.
Number 33, People versus Hillary Marshall, 22321 FH.
Good morning.
Good morning. All right, and Miss Bay, can you hear me?
Hello?
Miss Bay, can you hear me?
Yes.
Okay. All right, I can hear you too. All right, this is 240P01688. This is the People versus Lita Bay. Officer Milosh, would you please state your name?
Yes, ma'am. First name Nathan, Nathan. Last Milosh, Mloche.
And Miss Bay, would you please state your name?
I'm the executrix of the estate for Lita Bay.
All right, we're here today for, looks like a ticket that was issued back on July 14th of 2024. All right, Officer Milosh, it's the government's burden. So you'll go first. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth and nothing but the truth under the penalties of perjury?
I do.
All right, so what can you tell me about the ticket that was issued on July 14th, 2024 to Lita Bay at Coolidge and Pearson in the city of Oak Park?
Yes, ma'am. The citation was issued due to Miss Bay disobeying the red light at actually Coolidge and North End. Once we got through that intersection, Miss Bay did come to a stop at Coolidge and Pearson. And then once that light cycled through, I initiated a traffic stop just north of Pearson, just south of Albany on Coolidge there at about approximately 10:45 p.m. At that time, I went up to speak to Miss Bay. Initially, she refused. She did provide a license and eventually started speaking with me. Returned to my patrol vehicle, at which time she exited her vehicle, went to the rear of her vehicle, opened up her trunk. Went up to speak with her and escort her back to her seat in her car, at which point she started resisting. So my fellow officer and I took her to the front of my car, spoke with her, initially handcuffed for officer safety. We released her without charging her for the misdemeanor for resisting obstructing, and we just went with the disobey red light. And actually at minute 158 of my body cam, Miss Bay does admit to the infraction of disobeying the red light, stating she had to use the bathroom.
When you say resisting, what do you mean?
So initially we went up to her, asked her to step away from the trunk. Obviously we didn't know what was in there. She then began to retreat from officers. We then grabbed her arm to help escort her to her vehicle, at which point she tensed up, pulled away, and started screaming at us.
What do you mean by screaming? What did she say?
Am I able to reference my report I have here?
You may.
Thank you. See, initially she said, that we were fixing her things. She was
you're
nervous
breaking up. I
because
can't.
we've gone near. Oh, can you hear me now?
I can hear you. Yep.
All I have here is that she kept screaming, "Help me!" initially, when she was in her vehicle, she stated she didn't want to speak with us and that we were forcing her to say things against her will, and that she was nervous because we had our sidearms and we were near her children. Once she was resisting, all I have noted here is that she kept screaming, "Help me." And that's all I've got in terms of that. I don't have access to my body camera footage at this time.
Why is that?
This is virtual court, so I don't have access to evidence.com. I don't have a work computer, so I didn't know if it was appropriate to access mobily.
All right. And Miss Bay?
I'm the executrix for the hi, I'm the executrix for the trust for Lita Bay.
All right, Miss Bay, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth under the penalties of perjury?
I do.
All right. What can you tell me about the ticket that was issued to you?
Your Honor, I actually put in paperwork and asked for discovery, and I was advised that I shouldn't testify until I get my discovery packet.
So this isn't a criminal case. It's a civil infraction. You were free to order under the Freedom of Information Act any information regarding this case prior to the hearing. So it's not like a criminal case. It's a different standard. It's just a preponderance. It's not beyond a reasonable doubt. But you most certainly would have had access to that if you just FOIA'd the report or the body cam in this case. But we are having the hearing today, and you're free to give me your side of the story if you so choose.
On the day in question, I went through a red light. I had to use the bathroom, like really desperately. I had 3 teenagers in a car with me. And when the officers approached my vehicle, touching their sidearms, my daughter had the identification, and I explained to them that this was a trust situation. And they didn't care. She was terrified, and she ended up taking out my ID because she did not want us to get killed or beat up or anything. Because things have happened to family members. I didn't want to get tased. She didn't want us to get tased or beaten or killed. So she ended up taking out my ID because I did not have to identify. It was not a situation for identifying, but we were forced to because of the guns and stuff. And my children were terrified. My son's girlfriend was in the car. She was terrified. I told him it was a trust situation, and I told him I had to use the restroom, and because he said something about me going through the red light, which there was no traffic. The traffic light is to direct traffic. There was no traffic. I really had to go, and I was really trying to get to the destination because I have a medical condition that's life-threatening right now. So I explained it was a trust, and they went to the car, and I got out to get tissue out my car, which I have a receipt and a picture that I did have tissue in my car. I was going to use the bathroom on the side of a house or wherever because I was not going to expose myself to waste matter with my blood condition. They came up to me and they was like, "Ma'am, what are you doing?" They all rushed towards me. They all grabbed me. Then all of a sudden, somebody had their hands between my legs, brisket touching me, my breasts, searching me. They pushed me up against the car. They put cuffs on me in front of my children. They put me in the back of the car. I was screaming for help. They went up to the car and they were taunting my son in front of his girlfriend and his little sister who looks up to him. Like, I said, I just had to use the bathroom. I asked them nicely. I said, "Can you please just sit me on the ground? I do not want to waste inside of your car." I wasted myself in my car once I got in my car after they put me in the back of the car. So that's what happened on that day. And I asked the officers, "How would you want your mother handled? I'm an older woman." And he did this in front of my children.
I'm not going to lie. I had to look up the word executrix because I wasn't sure if it was actually a word or not, because we know with sovereign citizens, sometimes they can make up things, but it actually is a word, and it is basically a female executor of a will. But just looking at this case, a lot to unpack here, a lot to be said about everything that happened during this traffic stop. We hear what she says. She says, listen, I ran a red light. I had to use the bathroom. And it's hard to dispute that, right? It sounds like she definitely did. I mean, for her to go to the trunk, grab tissue out of the trunk, it seems like she definitely had to go. She says she has a medical condition, which I'm sure she can just prove by medical records. But we have to also look at it from the law enforcement side that, listen, you're going to your trunk. We don't know what you're getting out of your trunk. Yes, you're going to get tissue because you feel like your situation is urgent, and it is. But the unfortunate part is you broke the law. You ran through the light, right? And this is why you were pulled over. And she talks about the police not handling her well, how they were poking fun at her son in front of his girlfriend. And all of those things may be true because I've definitely seen cops at traffic stops get a little silly and goofy and, sometimes even power tripping, right? So I'm not saying that that's not possible, but here's the bottom line. We don't have any body cam footage to prove who is telling the truth. But at the end of the day, it seems like she's definitely dealing with some medical issues. She said that she was scared. That's why she was yelling, help me. But was she really scared? Was she really terrified? Is the things that happened to her family members or friends in the past something that sits on her mind? It's a possibility, right?
I went to the temple earlier that day, in the Hindu temple, and did sacred rituals. Wasn't nobody supposed to be touching me. And somebody just came up to me and was touching between my legs and my breast. And I don't know where they came from, and they were all surrounding me.
Anything else you want to say, Ms. Bay?
I was screaming for help because I was terrified for my life. I was not guilty of anything, but needing to use the bathroom and not wanting to soil myself. I just wanted to get to my destination, which was off of Oneida and 9 Mile, which literally 2 minutes away. I did not make it.
Okay. All right, the court has heard the testimony from Officer Milosh and from Ms. Bay in this case. The standard is preponderance of evidence. Mr. Milosh testified that he saw Ms. Bay run the red light at Coolidge and North End. Ms. Bay acknowledged running the red light in question in this case. The people's burden is satisfied beyond a preponderance of the evidence in this case. I'm finding Ms. Bay responsible for running a red light. The fine is going to be $165. You'll have till October 1st to pay it. I will send that to the Novara address where we sent the other notices, so you'll get the paperwork in the mail. You're all set.
Excuse me, Your Honor. So what I'm asking you is, I have a question. You're telling me, is the court telling me that trust situations are not seen as trust because this is a trust matter? This is not what
so
you
Ms.
think
Bay,
it is.
there's no trust situation recognized by the court. You are responsible. Make sure you pay the fine by October 1st.
Oh, sure.
All right, you're all set. Have a great day.
Very much.
Well, we see she wasn't too happy with the judge's decision. We see that she basically asked her question and logged off before the judge could even really answer the question. But like I said, we don't really know everything that happened during the traffic stop without the body cam footage. But just like the judge said, and she found her responsible because bottom line is she ran the light. She admitted to running the light, and that's what they really were there for. All of the other stuff is definitely important because we want traffic stops to be handled well. We want people to be handled well. We want the people to react well to the officers also. But at the end of the day, this had to do with running through a red light. She was found responsible, and now, she has to pay the fine. But as always, thank you guys for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, comment, share, and subscribe. And until the next time, guys, Sovereign Citizens Court is adjourned. I appreciate you guys, and God bless.
All right. It's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on one second.
All right. Good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you
Here
please
I
tell me?
am.
Well,
I'm here
please tell me
physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, they are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent to that.
I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on, what am I doing here?
Well, right now you are not responding to my questions. So
Well,
I'm
you're
going
not
to have you
responding to any of my. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything. I'm not perfect.
I'm in person so that we can be sure that you understand what's
All
going on.
right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
Right. Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of your appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for the record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today if that's what you want to do. We'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I have no idea anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list. This was not meant to be any kind of punishment, I promise. So we'll do, so Mr. Jeffries, just, get ready like you would. Probably it's going to go straight onto a jury. And we'll just get it figured out that way. All right.
I'm not threatening you. Say one more word and that's contempt. 30 days. 30 days.